for having it. Court does call the case of People's State of Michigan versus Thomas Styron II.
Good afternoon, Your Honor. I'm pleased on behalf of the club.
Sir, state your name, please.
I'm George Styron II.
All right. This date time set for preliminary examination. Mr. Styron, you are here representing yourself. I would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer under the Motor Vehicle Code in the 3rd degree. That is a felony punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a $500 fine plus court costs. The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then you would be what's called bound over to stand trial in the circuit court. You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are desirous of continuing to represent yourself, you certainly have an absolute and constitutional right to do so. You will be held to the same standard that attorneys are held to regarding the court rules, regarding the presentation of evidence, and anything else along those lines, as well as questioning of the witnesses. Do you understand all of that, sir?
I understand everything.
Pardon?
I understand everything.
Okay. And, sir, do you still wish to proceed unrepresented? Very good. Do you have any questions before we begin the preliminary examination?
I haven't had a chance to look at the body cam and the evidence. I just got a kite back yesterday telling me I could ask the noon staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far. I'm able to get through the first
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive. And I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time and evidence to even review it, to be able to articulate it.
Excuse.
Your Honor, I understand that the APA that was present before me had intended to admit that some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Howe's testimony.
Right. I guess and I understand that misuse, and I guess the only question would be if whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, a count of felonious assault, which is assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm, which are mandatory 2 years in prison. So, Your Honor, I don't have a problem if we need to adjourn this room to have more time with the video.
Okay. Right. And under those circumstances, and I forgot, I think you had mentioned that before, that with that. Okay. So, Mr. Styron, you're requesting an adjournment of the proceedings so you can get through that. Is that okay? How far, and I guess I was unclear, you have access to the body cam?
Yes, I do. It's in my property.
Okay. But then you were talking about you got through some of it?
The first video, and I believe it's a YouTube, not YouTube, but a Facebook video of a bystander.
Say that again.
Facebook video that somebody took.
Okay.
And part of his body, maybe 20 minutes, half hour's worth.
When you're saying you're talking about
Officer Hooks, yes.
Okay.
I believe his body cam footage is an hour and 15 minutes in its totality. So I've barely been able to scratch the surface of that.
Okay, let me ask you Go ahead. Were you going to say something else on that?
And like I said, I believe there's 15 or 16 videos in there total. Maybe more, and that's just what I was able to see.
Okay, so let me ask you this. How are you arranging to view that video? Because
So originally I was kiting everybody I could. I was correctional services, the sergeant, that sergeant. Finally, while down in correctional services, I was able to speak with Sergeant Flint.
okay,
And he was able to arrange this first meeting. And like I said, I got a kite back from him yesterday telling me just to bother the noon staff, and they'll arrange it during the noon shift. So
gotcha.
prior to yesterday, I didn't. I was still asking. I guess I was just asking the wrong shift. I was asking later in the day. That's for certain. And I really was never able to get anything else arranged as far as being able to go and view it.
Okay, so you were trying to do it one way, that wasn't happening. You finally got to Flint, and he indicated to you that it's the noon staff you're supposed to bother to
Yeah.
try that. Okay,
Flint's definitely provided direction in regards to how I can go about getting this.
all right. Okay, so we'll need to then adjourn that. Have you, well, I'm going to ask it one or two ways. How long do you think it'd take you to get through it? I mean, how long do you think it'd take you to get through it? I mean, is it your, and I won't hold you directly to it, but I mean, would you be able to do it in one day if you had access to it, or is it going to take you a few days, or just your best guesses? Because you know how long the clips are. I don't have any idea by
So,
design.
I only have knowledge of how long his particular video is, Officer Hoops. I don't, the other ones I haven't looked at, viewed, can't remember how big the file is, nothing like that. If I was out in the world, I could probably have this done within a week at my house. I have my own computer, and I planned on originally being able to do this. Also, it depends on the jail. They've been so short-staffed. We've been locked down a lot as well. So it depends on what their staffing numbers is during it. When I'm asking or trying to arrange this, there's so many variables. It'd be hard for me to give you a.
No, that's fair. That's fair.
And then also,
But you don't know total. You don't know total time how much there is. You just know that one.
Since May, I've been fighting an illness that just recently the jails addressed. So yeah, there's so many things going on. I've been since May. I've been having stomach issues, bowel issues, and on Friday or Saturday I was urinating blood. Finally, I was able to get some the medical staff to do something with that as far as me urinating the cup and give me some type of antibiotics, but all they can tell me is I have an infection. They just don't know specifically what type of infection. So I'm also dealing with that, and it's making me very lethargic and
Okay, I got you.
energy in that.
What do we
Progress
got?
that as well.
What do we look like on the 6th? Well, we've got stuff. It's a day like today. I got stuff in the morning, but then, okay, so that we hopefully won't run into this again. You've gotten all of the discovery.
Pardon me.
You got all of the discovery. Like you got the, as far as you know, you got the police report. You have all of that. It's the video. All right. So what I will do is I will adjourn the preliminary examination in this matter. I would go to the 30th, but I think I'll go to August 6th, 2024 at 1. I'm going to set it at 1 p.m. We'll just push everything else out of the way, and that way we'll be here. So that'll give you 3 weeks to try to get through that. Now, if there are issues like what you're talking about, short staff, whatever, and you haven't been able to get through everything, talk to one of the deputies so that they can get in contact with my office, so that if we have to push it out another week, we can just get that done without you coming up here telling me you're not ready.
Fair enough.
Okay.
Got a question in regards to is there any reason why that would be preferred instead of me being able to address what I got going on internally and at a hospital or outside in the world. I guess me being put on bond so I can take care of my illness as well as look at this discovery and handle that. So it'll be done in a more timely manner. There's less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no communication from the jail to that effect, which tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond for the defendant's demeanor in this courtroom. At the time that my office charged this case, we requested a $50,000 cash surety bond. This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I'm planning to run the information against him. Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Howe took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is, when I said cook, I made it very clear. Said meant legally in the courts, which he iterated on his body cam. So according to the body cam video, he was fully aware that I meant legally through the court process. And also, I believe in the police report, he was sitting there for a welfare check with a possible wrong domestic, which led me being pulled over. Me being a single person in my van, not two people, which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my parents' description, based on who was looking up in his talent or the lane system or whatever it is they use in the police cruiser. Make sure they ready that I plan to use the legal system to address any transgressions or trespasses I felt was made against me. Also, I was the one who stayed on top of these charges. I'm the one who called the court every day, stayed on top of this case, and I'm the one who arranged the court date with Ms. Fink. I was the one who called the courts week after week, and they didn't have my case in, and finally they did. I was very proactive in trying to get this addressed through the court system. I had no intention of running or trying to avoid it at all. And I think my actions would suit such.
In this matter, I'm not going to, at this point, change your bond, Mr. Stern, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to certainly, I hear the allegations. I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that date, at least as I understand them to be at this time, that you pose a significant risk to the public and to public safety by your conduct that day. Okay, I'm not sure about the comments. We'll deal with that. Further, as the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you, I could trust you to do what I ask you to do. This is the first time today, as we were talking to each other going through the things, that it's been a civil conversation with you to try to resolve the things. All I'm trying to do is get the case through. I don't know why the other days you made a determination to try to act a particular way to the court, because I'm just, like I said, I'm just here trying to get the case heard and get everything done. And so I have, based upon what I hear regarding the case, what I also have seen in terms of your demeanor in the courtroom, I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th, and I certainly will relook at everything on the 6th and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are. And I'm not saying you're guilty of them. I'm not saying any of that. But in terms of the allegations and what could be and is, from this court's perspective, a situation where you may pose a risk to the community, but also a lot of it is of your own doing in terms of what happened here. Okay. And so all of that I have to take into and can take into consideration. But like I said, in fairness to you on the 6th, because today was 180 degrees from before. And so I will now factor that in. And on the 6th, certainly I will take a look at anything you just raised again before the court. Okay. And I would agree, just real quick, and I'll let you. I would agree with what Ms. Hughes has said, and that is that if your medical were to an extent, our jail is excellent. I have to say the sheriff's office is extraordinary in making sure that people get the medical care that they need. But certainly you would have to apprise them of that, and I think maybe you have, and they will make sure that you're taken care of. I just don't have a doubt in my mind and have never had an issue with an inmate getting the care that they need. So, all right.
Two things. 4 times we've been adjourned because I asked to represent myself. I don't believe my demeanor played any roles in that. I thought it was because there was some misunderstanding as far as the courts and trying to represent myself.
Oh, no.
And in regards to the medical thing, I reported this in May. It took until I got a flood in July before anything was ever followed up on or done.
Okay. I'd suggest that you send another request regarding the medical issue. And Mr. Styron, I would also suggest to you, it never is an issue. I've had 2 others come through representing themselves. That is never an issue with me because you have a right to do that. Yeah, and I'm just going to let you know that is not the reason. You need to go back and you need to look at what you were doing in this courtroom or this court for reasons I don't even, Mr. Styron, understand. So I'm not here to debate that with you. I'm just telling you that's where it was.
I wasn't implying that, Your Honor. What I was saying was maybe I was misunderstood. That when we went to proceed with the court proceedings, there was some misunderstanding in regards to the public defender's office representing me versus me representing myself. And since there was that misunderstanding, it was adjourned, I believe, 4 times over those matters. It wasn't because I was acted out or anything. I believe I came and went so fast. It wasn't even opportunities.
No, there were a couple of adjournments because of that.
Okay.
But that was because you needed, there was assistance you needed in regard to what we were dealing with at a particular given moment. And so that's where the PD was standing in. But no, it was your behavior on the date that I revoked your bond. And then the other dates were trying to make sure of that. And I was, just to be honest with you, Mr. Tyron, I wanted to make sure that you truly wanted to represent yourself and that your rights were protected with having the PD here. And until I was clear on that, I wasn't going to let things proceed because, well, I'll just put it to you bluntly, you got a hot head sometimes. And I wanted to make sure you weren't making that decision just because and not fully understanding what this was, because these are serious charges and there potentially more that are coming. That's my whole thing on that. Okay.
I appreciate it.
All right.
One last question, if we're about to be done. In order to get a hold of your office, I can use the channel of the jail, not the mail system, because I don't have envelopes to pass information or anything. The jail is my channel that I go through to contact you and inform you of certain things, be it whether it's documents or
I'm not, well,
or in regards to me needing more time?
I think you would
perhaps?
have to send some type of communication, written communication to my office. I don't think there's a direct line, and I'm not even sure how that works because I usually don't have inmates contacting my chambers directly. Sometimes they will mail things, which seems to me to not be it. Do you? Oh, there he is. So he'll figure that out. He'll let you know how to get a communication up to my office.
Right.
Okay.
Yeah.
And not whether or not I can do anything about it, I don't know. So when that happens, so that you understand this, Darren, whatever you send to me that I'm going to review needs to also go to the other side. But what I will do to try to make things easier, if this is okay with the people, is that once it comes to me, I will make sure that whatever you're sending to me, they're going to get a copy.
That works, thank you.
All right.
Envelopes are $1 and I have no money in my account, so it'd be very burdensome to try and buy envelopes to send to everybody.
They're $1? Seriously?
No, down there.
I got about $500 in back. That. Okay.
So
Why? No, I'm just saying, if I can sell it for $1, I'll just take the whole box down. Anyway, okay. So we sorted that out. Make sure to get with them. They'll make sure it gets up to us.
perfect. Thank you.
Okay,
Yeah.
Mr. Syra, I appreciate you behaving yourself this way because just listen, because you're coming in hot like you did before. I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that. And my only response to that is I've never had that happen. All the other judges have ever had one from whether check. Miss Spink, Miss Spink that was able to have a conversation after the court time.
She's nicer. She's nicer than I am.
She's a very nice woman, that's for sure. And
She's much nicer than I am.
like I
And
say,
so
they-
she has patience. Sometimes I don't.
fair enough.
So you got to take it as it is. All right.
Well, have a good
Thank
day.
you. You do the same.
Thank you.
I don't know that I could say I'm going to do this after a hearing because she is highly inebriated. She's a .224. Court recalls the case of New Parker Apartments versus Tubbs.
You say for the plaintiff, Your Honor, our decision to wait for Ms. Stubbs paid off. She's here.
State your name.
Sherry does.
Okay. Where are we on this case? And then I have a question.
There,
Goodness. I usually don't bring
this
my
is the
comments.
worst thing that happens today.
I know, I never do that. I'm sorry. I never have my.
The sex offender registry still shows Mr. Gardner is living there. There's I found in there somewhere where it looks like there was some check made on 8/27 of 25, so in August of this year. I don't know what it means. I'm not saying that that means they confirmed it, but there's a date in August of 25 in the sex offender registry records. And I did a Lexus person search, and apparently his driver's license is at her address still. She acknowledges that it has not been changed. I given Officer Allen the default judgment. I think it could now be after hearing, and she says she wants to try to get this done. And so if the court gives her more than the 10 days.
Yes,
we want
because
to-
he had went to the post office and changed all his mail, which last time I was here, I didn't know.
Miss Tubbs, before you go on, have you been drinking?
Yes, I have a couple of beers, yes.
How much did you have?
I drink beer. Like,
Okay, so how many beers did you have?
18 ounce or 24 ounce, yes. I would.
Yeah, that's the nice thing about the 24 ounce. You can say I only had 2 or 3 beers.
So this morning? Can you get Teresa down here with the PPT, please?
I will say like 2 or 3 or 4 o'clock in the morning, because that's what,
2 or 3 o'clock in the morning, you started drinking?
that's what time I usually get up and drink milk here.
Okay, so how many did you have this morning?
A beer.
Just one? One, what, 24 ounce?
24. Well, that's how it trade, yes.
So that's like 2, but what kind,
I
what,
don't know how much come into 24 hours.
24 ounces. So, what kind?
But like,
Oh, of course. Bud Light. Why did I
yeah,
ask?
I drink Bud Light. I used to drink Miller High Life, but I drink Bud Light. I used to drink a lot of liquor, but Bud Light. Why would you ask me?
Because I've got to determine whether or not you can adequately do this hearing. Mr. Allen, Mr. Allen, I'm going to give you a PBT.
What is that?
Okay, that's a preliminary breath test.
Oh,
Okay,
okay. Okay.
so here's what's going to happen. You're going to go back with Mr. Allen, and there's going to be a PBT. You just need to blow into the machine, and then we're going to see. Okay. Thank you, Miss Tubbs. Watch your step. Okay, bye-bye. I know. Glad that's what came out of her mouth. All right. You know, there are times in life where I'm just afraid to call another case. Just kind of take a pause and you just hope.
Hey.
Are they?
They're doing what they do.
Okay.
Some people wake up in a number that would send other people to bed.
I know. You know, I was just gonna ask for breakfast, really? I don't think. Off the record? No, I'm gonna say what I gotta say. Because
Who's getting that to whom?
I'm not really sure, but I'm afraid to go back and look. Is Mr. Lloyd, is yours simple? Where's Lacey go?
Very fast.
Oh.
That's what Magnus said. And then no. No. Corey, go.
We heard you.
Oh, holy. Okay. Hold on a second. Miss. Okay, Miss Tubbs.
Uh-huh.
Okay.
Yeah, I already know. I was drinking last night too.
Yeah.
I already know what it was gonna be, Miss, Stunson.
Uh-huh. Okay, so let me first ask you this, and then I'll try to see what we're gonna do with your case. How'd you get here?
I got dropped off by my sister.
You didn't drive.
No, I don't drive.
That's probably a good
I don't
thing.
have a license, so I don't drive. Nobody.
That doesn't stop everybody,
And I'm
but
getting on the bus when
okay, so Mr. Fink, I don't know that I could say I'm gonna do this after a hearing because she is highly inebriated. She's a 0.224.
What does that mean?
It means you are seriously.
That's probably about 3 feet to the wind. Never mind. You don't know what, off of one beer? No, you had more than one.
Okay, I played a drinking game too, so that was it. Oh, man, did I say that out?
The courtroom fell silent as the self-represented defendant stood before the judge and explained why he wasn't ready to move forward. He calmly told the court that he had received the evidence, but because he was in jail, he had only managed to watch a small portion of the body camera footage. According to him, there were more than a dozen videos, and limited access, lockdowns, and health problems had made it impossible to prepare a proper defense. Rather than asking for special treatment, he simply requested enough time to review every piece of evidence before the hearing continued.
Like, I played a drink game.
Your Honor, the efficient thing to do would be to come back on Friday with a regular landlord-tenant docket.
Yes, it
But
would.
the kind thing to do would be to maybe come back the next Friday so she can have one more shot at trying to get him to the state police and get his ass.
No, but the state police is way out in, right now have
You
transportation.
don't have to go there. Willie Gardner's gotta take care of this, or you're gonna get put out. And everybody's-
Oh, he has to,
Everybody's trying to
believe
save
it.
Tennessee.
I'm just
We need to
walking
get
out.
on the team with us.
oh,
So how about
come on, Mr. Simpson.
26, Your Honor?
Come on, what?
Judge Simpson, I do not need to be paid. I ain't had a permit in 15 years and I finally got my own permit. I know this was a sex offender or none of that stuff.
Okay, so
But when I come back, I'm gonna be
On,
here.
on the regular docket
On
on
the-
26.
on the 26th. Okay, so here's what I'm gonna do. All right, I'm going to adjourn this, and it's gonna go back to basically a pretrial for September 26th, 2025 at 3 p.m. That's in the afternoon.
Oh, yeah.
Okay,
Cause
so
I'm gonna drink at 3 a.m. I'm just playing. I'm just playing.
okay, I just Miss Tubbs, Miss
I appreciate you, Judge. I really do.
Miss Tubbs.
Just not have people get up on first.
I know, but Miss Tubbs, here's okay. I'm giving you basically 10 days to sober up and get that.
Sober today. I'm not drinking no more today. I promise. I ain't gonna drink no more till the 27th. I'm just saying. I just try to keep my apartment.
I know. So I'm not.
Two grandkids, and
Okay.
they never come to my apartment.
Okay, I'm not gonna get into that. All I need.
Say 32.
31 grandkids, 10 kids, 31 grandkids.
31.
31 grandkids, 10 kids, 5 boys, 5 girls. And they love coming to my apartment, just, they don't live with me, but they just like to come and play.
Okay, so here's the deal. I'm gonna adjourn it out to the 26th at 3. Next time you walk into my courtroom, you need to be sober.
Promise. I got a Bible in my purse.
No, let's not do that.
The judge carefully listened before asking several questions about the defendant's access to the videos. After hearing both sides, even the prosecutor admitted there was no objection to delaying the hearing since the body camera footage would not be used that day. The judge agreed that fairness required the defendant to review the evidence first and officially postpone the case. But the hearing didn't end there. The defendant then requested bond so he could receive medical treatment and prepare outside jail. The prosecutor strongly opposed the request, arguing that the charges were serious and that the defendant remained a potential danger to the community. Although the judge acknowledged the defendant's respectful attitude during this hearing, he ultimately denied bond, explaining that both the allegations and the defendant's previous courtroom behavior could not be ignored. Before ending the hearing, the judge left him with one final warning. Continue showing respect in court, because coming in angry or combative would only make a situation worse.